So a lot of people will call about a slip and fall on ice or snow. And those are really tough cases to win as well. You have a high burden of proof. You have to prove um, that the ice or snow was there for a sufficient period of time, that the owner had a time to remove it or apply salt or sand if they can't remove the ice, right? And how long has it been since it stopped snowing, right? So there's what they call a storm in progress defense. So if you're slipping and falling on snow, but the storm is still, going on, there's no obligation by the owner to go out there and start doing any remedial measures. Right. It's after the storm stops and then a reasonable amount of time. The city of New York has their own code for the sidewalks. They give you a certain number of hours to get it cleaned, but they don't include the overnight hours in those times. So it depends on what time of day or night you fall,
Right.
how many hours have gone by, when did the hours start. So there's a lot to go in. But on Long Island, we don't have that. So it's just a reasonable amount of time after the snow stops. You're not going to need your burden of proof to show that the homeowner or the shop owner was negligent, because a reasonable person is going to wait till the snow stops and then go out and clear it. Listen, as a homeowner, the mail carrier, or some people actually get Amazon packages.
Yeah.
So, these people are, going up and down your steps. So if the snow has stopped and you're lazy, you don't get out there, and it's been, several hours and you've done nothing, and they take a fall, you're going to be at fault. Then when the claim comes in, you're going to have to send it into your homeowner's insurance carrier. And everybody knows homeowners insurance has been skyrocketing. A lot of people are getting canceled for not even putting claims in. So you really don't want to have to put a homeowner's claim in because you were lazy about getting out there in time to shovel. And a lot of times, if it freezes overnight and it's a sheet of ice, put some sand or salt down. You don't have to cover every inch as long as you're doing something that's reasonable. The definition of negligence is someone doing something that an ordinary person wouldn't do, or a reasonable person wouldn't do, or failing to do something that a reasonable person would do. And that's all the reasonable standard. But when we bring a case against somebody for negligence, that's what we have to prove. It's a reasonable standard. And then your contributory negligence comes in. Okay, well, how careful were you being? Were you in a rush? Where were you looking? Were you taking your time? Were you being careful? So even if you prove the homeowner or the shop owner at fault, then the next step is, well, what fault did the person that fell have, right? And then if they're also at fault, and then if it went to trial, the jury would decide who's at fault for what percentage.
Right.
And if we're not talking about slip and fall, say we're talking about trip and fall. Well, what did you fall over? And there's a defense, open and obvious.
Yeah.
Well, if something is there and it's so big that obviously you should have seen it and avoided it, and you didn't, you could be found 100% at fault for tripping over something that you should have seen.
Wow.
Right. So, and then there's trivial defects where something is so small, you scratch your head and you're like, there's no way that that has to be in dangerous and defective condition. So is this something? Is it a tripping hazard? Is it a trap or a snare, as they say? Or is it something so trivial that normal person would be able to walk past this and not trip? Right. So the trip and falls, the slip and falls, they're not the easiest cases to bring.
It's a slippery slope.
Yeah, but and a lot of times they get dismissed. So you have to be careful, and you have to do your investigation, your due diligence, get the photos, get the measurements. Always, if I'm going to investigate a scene, I bring my phone, I bring a ruler, I bring a level to decide, is this something that if a jury looks at these photos and the measurements, so they're going to say, hey, listen, you know what? That's a dangerous, defective condition.
Yeah, right.
It should have been.
The stairs. That one stair is an inch taller than the other one, and nobody realized it.
Yeah.
Yeah, that's interesting.
I was just out east doing an inspection at a catering hall where there was an outside area that's covered, but the person was moving from the main room into this added on outside room. There was a bar there, and there's flooring, but where the two floors met, they weren't even. So there's a step down. So how did they handle the step down? They didn't have a step. They put like
that tape.
piece of wood, right? So it's like a gradual step down, like a big saddle. So
Sounds a little dangerous.
if you're just looking at it from far away, you say, "Oh, listen, nothing." But when I went there and I brought a level and a ruler, and then I put the level, I laid it out,
Yeah,
on your stage. Wait a minute, someone's, the step's going to be thrown off stepping down. There's no warning tape. There's no signs. You're at a wedding. You're being social. You've got a drink in your hand. You're not staring where you're walking. You're assuming the area is safe for you to walk.
Right.
And this lady took a tumble,
Right.
and she broke her leg.
Wow.
It shouldn't have happened. And clearly, we're in discovery now. We're trying to get all the documents about whether this has happened there before. I have to take depositions of the people that run the catering hall.
Right.
So they say, "Hey, listen, has it happened before?"
I'm sure.
And whether they're going to be honest about telling us about it or not. So we'll run a lawsuit search to see if the catering facility has ever been sued before. And then we'll look into those pleadings to see what was alleged. And that's another way we can build the case.
Yeah.
Well, it has to be for the same issue, right?
Yeah.
They're sued, but if there was the same general area.
They didn't fix it after everything.
And they're on notice of it. And I've won lots of cases on videotape. So, and we were talking about someone getting hit by a forklift. I had one of my biggest cases. I was over at JFK Airport, and my client worked for DHL. He's making delivery at one of the terminals, and one of the guys employed at the terminal is backing up in a forklift, not looking where he's going, and it's all on video. And you see he just, at a high speed, and the forklifts go super fast, but he wasn't inching.
Fast enough.
He nails my client in my client's back, and he sends him flying.
Oh my God. And like the spike, like that, like the lift part, the forklift part.
My guy wasn't a small guy, and he had a rough landing. He ended up having some horrible spinal injuries or multiple surgeries, and the video won the case. So there's 2 points of every case. There's liability, which deals with fault. Who's at fault, right? And then you don't get to the damages part, which is the injury part, until you prove the fault part. So if we go to a trial, the jury's not told about injuries until you prove it's someone's fault.
Right.
And then, because the courts don't want sympathy playing a part in the jury's determination of who's at fault.
Which makes sense.
Right? So we only talk about and present evidence about who's at fault. Was there a dangerous condition? Was someone negligent, right? So here, the video was clear as a bell. And so we made an application on paper to the judge saying, "Judge, look at the video. Based upon the video, there's nothing our client could have done. There's no contributory negligence on his part. It's 100% clear that it's all the forklift operator's fault. We want a determination of what they call summary judgment, a judicial finding that the driver of the forklift is 100% at fault for causing the accident." And we made that application. There was really no defense the defense could put on. So it was granted at the early stages of the case. Now, the advantage of doing that is that when my client's deposition came up, which can take hours and hours, the whole part of them asking questions about how and why the accident occurred was no longer part of the deposition.
Now it's about
Because it was already decided. So yes, were you struck by the forklift? And then what happened to you? And the deposition proceeds from there. But you just saved my client, 2 hours of questioning about how and why the accident happened.
Right.
That's great.
Right.
Takes the anxiety off of my client, the pressure off of my client. Number 2 is that once there is a judicial determination of fault, statutory interest of 9% starts to accrue from that day. So, not for settlement purposes, but if the insurance company decides to play hardball,
9%.
drags this case out for years and wants this to go to trial and get a verdict, if I'm forced to get a verdict, I now get 9% interest dating back years before from when I got that determination.
So they want to settle at that point, basically.
You're Your job as a personal injury lawyer is put as much pressure on the insurance company to do the right thing and make a fair settlement offer.
Right.
No one wants to go to trial. Trials are risk for my client, they're a risk for the insurance company. But my job is to make it even more risky for the insurance company than my client. And that often leads to an outright settlement or a request by the insurance company to do a mediation. Hey, let's sit down with the retired judge, let's present all the facts, and let's try to hammer out something. And mediations are great because it's taking away some lawyers are like, we're taking a verdict, we're trying this case, we're trying this case. Listen, you have conservative jurors. People, it's not the lotto.
Yeah.
People think about giving other people money. If your client isn't the most likable, even if they got hurt, not everybody's star witness. Not everybody comes across sympathetic or empathetic. And so, as a personal injury lawyer, you have to keep in mind who your client is, how relatable they are, how likable they are, how well spoken they are, how comfortable they are speaking in front of people. If you ask 10 people, how many people would say that they would be comfortable sitting on a witness stand in open court next to a judge, having a stenographer take down every word, being asked questions by their lawyer, being cross-examined by the other lawyer, having 6 jurors and 2 alternates staring at them for hours a day? Nobody wants that.
Yeah.
Sometimes it's a necessary evil.
Yeah, you have
right?
a choice.
But if a lawyer is doing their job by doing everything they can to obtain all the necessary evidence to win the case and show the insurance company, hey, listen, you make us go to court, it's going to be your problem, not my problem. So you do that by documenting all of the evidence showing it's their fault, their insured's fault, and then carefully documenting all of the injuries, the pain, the suffering. And everybody says pain and suffering, but really pain and suffering to me, for my clients, it's more about loss of enjoyment of life, or what we call loss of quality of life.
Yeah.
It's really, there's the pain, ouch, it hurts. But it's more about, wow, you know what? I used to like to go for long walks. I used to like to pick up my kids and play with them. I used to like to walk my dogs, go to the gym, ride a bike. I used to go dancing. I used to go to movies, whatever. All these things that used to make up the reason we get up in the morning and we're happy and we smile. And now, because of the injuries, it's not there anymore. That's what is part of pain and suffering. And that's where I like to focus on when we go to trial, is to really emphasize to my clients, relaying to the jury how the pain and discomfort has affected your life. And sometimes we'll have a day in the life video done. We did that once. Sometimes, if like my partner handles medical malpractice cases, sometimes these people are not likely to survive going to trial. They're going to pass away before we get there.
Wow.
So we'll do a day in the life video to preserve their testimony at trial.
Well,
But we did a day in the life video, one of my favorite clients, and sanitation worker, he's facing the back of the sanitation truck. He's dumping the garbage into the back of the truck.
something explode or something.
And a construction man comes up behind and rear ends the garbage truck, crushes him up against the back.
Holy shit.
Both of his legs. I've never seen so many devastating fractures, injuries to the tendons, the muscles, the amount of pain this guy went through. And he was a tough guy, and he wasn't a complainer.
Wow.
And those are the people you really can go to bat for, because you can see, and he wasn't old, he had a wife, he had a young kid. You saw how this guy's life was upended. I mean, it's a miracle he didn't lose his one leg. But some days I thought that maybe he'd be better off losing it because I think he had more than 10 or 12 surgeries on the one leg alone. And you see people get through that, it really makes you go to bat for them because you see how their life has changed. And to see him not be able to do the thing he used to love, to go down to the pier and fish with his kid, he couldn't do it anymore. He used to be rough and tumble on the floor with him. He couldn't do it anymore.
Yeah, that's so sad.
You know what? And it affects him physically, yeah. But think about how emotionally, and whenever there's a serious injury, it has a effect on the marriage. It's very tough on the spouse. It's very tough on the relationship. It affects everything. A serious injury affects every part of your life. And so as a lawyer, it's your job to document everything, to prove the fault, to prove the extent of the injuries, and to prove the impact on a client's life. And that's what I do. Painting that picture, I can't paint, I can't draw, but I can use the evidence and the facts to make a presentation to the jury so they can feel what this person's going through, so they know what to do when it comes to properly compensating them. And that's, I've been doing this 35 years and I still really enjoy that. I get put in my 9 to 4 or whatever the hours are, work for the insurance company, get a check, and I can sit back and I can poke holes in all these injured people's cases, and I could do it in my sleep. I said, I couldn't live with myself. It's just not where my heart is. It's not what I'm about. From the little guy, the underdog, and going up against the big companies, the big insurance companies, and making them do the right thing.